We're going to start off today's webinar with a presentation from Morton Mosswild covering the basics of tree growth tax law. And then we have a little Q&A session after to go over some commonly asked questions. And then if you have additional questions while listening to that Q&A, please put them in the chat. If anyone has questions on how to do that, please let us know before we get started here. All right, and I guess I'll introduce myself. My name is Alyssa Gregory, and I'm the District Forester for the Mid-Coast. And Alex, do you want to turn on your camera and introduce yourself real quick?
Sure. Hi, good afternoon, everybody. My name is Alex Redfield. I work for the Bureau of Agriculture for Maine DICF. I help people with farmland protection and farm viability projects, and I'm here to address the intersection of tree growth and the farmland current use program as best I can. Happy to be here.
Thanks, Alex. So you guys are in for a treat today. You have two foresters and someone from Revenue Services. Morton, did you want to introduce yourself before you start your presentation?
Yeah, good afternoon, folks. My name is Morton Mosswild. I'm a forester with the State Forest Service, and happy to be here as well and providing this presentation on tree growth. So I'm going to turn my camera off as we get into the presentation.
I'm going to turn my camera and mic off too. If you have questions during the presentation, feel free to put them in the chat. I'm going to be monitoring that while Morton presents. Thanks.
Great. Well, again, welcome everyone. Thank you for being here. We're going to talk about Maine's tree growth property tax law, and we entitled this presentation "The Basics." Really, in the time that we have, we can cover pretty much the basics, not necessarily every detail, not necessarily every scenario or every question, but we certainly want people to leave with enough information that they can take the next step, ask intelligent questions, and find the resources that they need. So that's the intention for today's webinar. Before we get too far, I want to draw your attention to one possible source of help and information. That is Maine Forest Service's district foresters. There are 10 of them around the state, soon to be 11. And all of these folks have a wealth of information. They have quite a bit of expertise and background, and they're easy to find. So depending on where you live in the state, where your woodland is, there are resources for you. You can look for their contact information either on our website. You can just go to www.mainforestservice.gov, or you can always call the Augusta office at the number shown there, 287-2791. The district foresters have a range of responsibilities, and one of them is what we call direct or field-based assistance, also indirect assistance. And the translation of that is that if you are a landowner with more than 10 acres of woodland in the state of Maine, you can call your district forester and they will provide a free on-site visit with you to walk around your property, answer your questions, give you their impressions, and try to describe to you some of the different options that you may have for your property, depending on what your interests and goals for your land are.
I need something to drink.
So the district foresters are a great resource for that kind of assistance. And again, there's no cost to the landowner. Certainly foresters, loggers, and other audiences are also welcome to call us with questions for any kind of issues that you may be facing regarding trees or your woodlands. We do provide a fair amount of education and outreach in the form of workshops, webinars such as today's, field workshops out in the woods, presentations both online and in person. We work with schools. We have a presence at a lot of fairs. We have a lot of publications on our website. So getting information out to woodland owners and others is a big part of our mission. I just want to draw your attention to the fact that we do have grants that we administer. And one of those is an incentives program where we can partially fund forest management plans, or what we might call woodland resource action plans, for landowners. So that is an option for many landowners. We won't write the plans ourselves, but we will refer you to private consulting foresters who can do that work for you. So that's one option that many landowners may want to take advantage of. We also work with towns and nonprofits and have grants for those entities primarily through our Project Canopy program. The district foresters are also out and about. They're monitoring forest conditions and harvest conditions all the time. We do have a regulatory component as well, primarily centered around water quality and maintaining water resources in streams, lakes, rivers, wetlands, etc. So the Maine Forest Service district foresters are really your best resource for a lot of information and questions about really anything that you can think of relating to trees and forests. Today, we really want to just cover a few things. I want to talk to you about current use taxation, what that really means, provide a little bit of an overview of tree growth specifically and what the requirements of tree growth are and what some of the opportunities are as well. One of the questions we get asked a lot about is transfer of ownership and some other common issues that we'll touch on, and also point you towards some resources where you can find more information or get more help. So just for background, we want to make sure that people understand that what we're talking about really is property taxation. It has nothing to do with income taxes, but rather property taxes that are assessed by the town or the municipality. And under what we might call ordinary taxation, the assessed value of a property is based on certain principles that you might call just value or fair market value, or you might hear the phrase, the highest and best use of the property. And that's really I'm not an assessor, but those are the principles by which assessors determine the value of property on which to base property taxes for that particular property. Current use taxation takes a different approach. So under current use taxation, which is what tree growth is, current use taxation means that the property's assessed value, and we're talking primarily about land here, not buildings, the assessed value is based on how the land is currently being used, just as the name implies. So it's not based on the highest and best use, but rather on the current use of that property. There are four different current use programs in Maine that apply to property taxes or can apply to property taxes statewide. I'm only going to talk about tree growth, but Alex is here. He can tell you a little bit more about farmland, and then we can sort of share information as we can about open space. But really, these are the primary current use programs in Maine. The best source for detailed information for these programs is the Maine Revenue Services website. They have a property tax division at Maine Revenue Services, and all the forms and applications and publications are on that website. And the fourth one, in case you're wondering, is working waterfront, and that typically doesn't involve trees, so I'm leaving that one aside for now. There are some things that are common to current use tax programs, and I've just listed some of the essentials here. These are all statewide property tax programs. They're based on state law, and so they're really available to any eligible landowner around the state. However, they are administered by each municipality. So in any given town, the town assessor or assessor's agent is the one who makes determinations about any particular questions around a particular property. So the town assessor is always going to be a key figure in dealing with any form of property taxes, but that it would include the current use tax programs. It might be worth noting that if your land is in an unorganized township, the Maine Revenue Service is essentially the assessor for those unorganized towns, and they have a person dedicated to those programs in the unorganized towns. All of the current use tax programs have eligibility requirements for the land that's enrolled, and those requirements include how the land is being used and what makes it eligible for any particular program. One of the key features of these programs as well is that they usually reduce the valuation, that is the assessed value of a given property, and therefore the property taxes on that property are correspondingly lower as well. So that is one of the primary benefits to landowners for enrolling in current use property tax programs. As a result, or in exchange, I guess, for the reduction in the valuation, the programs all have significant withdrawal penalties for having the land change its use or changing the use of the land, or otherwise failing to meet any of the requirements that are laid out for that particular program. So it's important for landowners to understand that the valuation, the taxes that you pay on enrolled land is typically lower, and therefore that's a benefit, but you have to balance that out with understanding that there are requirements, and if you fail to meet those requirements, or if you change your mind about the use of the land, there will be withdrawal penalties associated with that, and they can be quite significant. So we want to focus in on tree growth now for the rest of this part of the presentation. Tree growth tax law has been in effect since 1971. It came about quite some time ago, and its purpose when it was enacted was really to tax forest land according to its productivity. So recognizing that land that's growing trees is productive, but it is productive in the sense that those trees have commercial value. It also had the intent of encouraging forest landowners to retain their land and improve those forest lands. So retention basically means that by reducing the property tax burden on a landowner, it becomes more likely, or hopefully becomes more likely, that they will be able to retain that land and manage it for forest uses. And in effect, the intention was to promote better forest management through a reduction in the property tax burden on those landowners. Promoting forest management, retaining and improving forest lands, taxing them according to their productivity, all of that really is in service of both maintaining a forested landscape and also maintaining a forest economy through the growth and ultimately the harvest of the forest products that are grown on that land. So there are a couple key things that I want to make sure people understand, and that is these are common misconceptions. So I just want to emphasize again that Maine Forest Service provides a lot of information and education and resources about tree growth tax law, but we do not administer the tree growth tax program. That is done by the town assessors. We do communicate with assessors. We get asked questions. We work with all kinds of different entities that want to understand tree growth, but we ourselves do not administer or have direct authority over the tree growth tax law. The second thing I want to emphasize is that tree growth tax law is not related to the American tree farm system. It's not that uncommon for us to get a question from someone who makes reference to their tree farm. And when you're talking about a tree farm, you're talking about a private nonprofit forest recognition program, but not necessarily about tree growth. So the tree growth tax law is not the same as the tree farm system. Given what makes it even more confusing is that a property could be enrolled in the tree farm program as a recognized tree farm, and that same property could also be enrolled under the property tax program of the tree growth tax law. So it does get confusing a little bit, but I just want to emphasize that these are separate programs. So here's a snapshot of what the requirements are for land enrolled in the tree growth tax law. One of the key features that people need to understand is that by law, the primary intent of the landowner who enrolls land in tree growth must be to grow and ultimately harvest commercial forest products on the enrolled land. So that is, again, in keeping with the purpose statement of tree growth. The landowner must have the intent to grow and ultimately harvest commercial forest products. The minimum acreage is 10 forested acres. That's a baseline and important to keep in mind. Another feature is that once land is enrolled in tree growth tax program, that enrollment, that status runs with the land regardless of who owns the land. So when it is transferred, it remains in tree growth, and those responsibilities then pass to the new landowner. So that's a really important feature to remember for people who, again, hopefully will have the intent of retaining their land, holding on to it for a long period of time. Properties in tree growth must have a current forest management and harvest plan, and that must be updated at least every 10 years. So we'll talk a little bit more about what that means, what that requirement is. They must recertify at least every 10 years. So recertification just means refiling with your town assessor that you are in fact retaining and maintaining your land in tree growth. It is not an option to opt out of tree growth. It's not like you can serve out your 10 years and then you're done. It is a requirement that you recertify, but it's not an option to unenroll at that point. There are cases where land is withdrawn, and we'll talk about that, but it's really important for people to understand that withdrawal results in some kind of penalty, and oftentimes those penalties can be quite substantial, and in some cases, very, very substantial. So it's not something for everyone. The requirements, as I've outlined here, certainly suggest that someone who's interested in managing their land for commercial forest products, maintaining it for the long term, has the minimum acreage, is willing to abide by these requirements and recertify every 10 years might be a good fit. For other owners, this program might not be the right program. Just a quick view of how land is valued under tree growth. As you know, the assessor determines valuations for ordinary property taxation, but under tree growth, the valuations per acre for classified forest land or enrolled forest land are established by Maine Revenue Services. Maine Forest Service supplies some of the data. Those values are adjusted each tax year, and 3 different values are provided for each county for softwood stands, mixed wood stands, and hardwood stands. So those are republished each year. Obviously, the number of acres times the value per acre as established by this method gives you the assessed value of enrolled land in any given year. And then, of course, the assessed value times the mill rate gives you the property taxes that you'll pay. And just keep in mind that we're just talking about the lands that are enrolled in tree growth. And obviously, if there are unenrolled lands or lands that are being used for other purposes, whether that's residential or commercial or anything else really that aren't growing trees, those assessed values don't change. Again, just to be very clear, the primary objective for classified or enrolled lands must be to growing, improving, and harvesting forest products with commercial value. Some of that definition might be obvious. So trees that are merchantable as saw logs or firewood or pulpwood, those certainly count as forest products. Maple syrup is also considered a forest product. So if you have lands that are devoted to maple syrup production, those could be eligible acres. Similarly, Christmas trees and wreath brush are forest products under the tree growth statute. So those lands can be enrolled as well. It's important to note that some of the other things that we think of as forest products do not qualify for tree growth status. So fruit trees, nuts, berries, other kinds of things that might be harvested or gathered, ornamental products are not eligible for tree growth. Doesn't mean they're not important, but they don't make you eligible for tree growth. So harvesting. This is, again, unfortunately, there are quite a few misconceptions about tree growth that are out there, and we'll talk a bit more as we go along. But one of them, a few of them revolve around harvesting. Harvesting of commercial forest products is required as recommended in the forest management and harvest plan that you have developed with your forester. So the harvesting at some point is a requirement that you show that you are actually harvesting commercial forest products. It's sometimes, unfortunately, the term tree growth is sometimes misunderstood to mean that you have to leave the trees there. They have to keep growing, and that's not true. Harvesting land is not prohibited under tree growth at all, quite the opposite. It's part of the intent of tree growth. However, it's also important to understand that harvesting on lands that are enrolled in tree growth is not regulated any differently from other land. So the regulations that apply normally to timber harvesting are just the same on tree growth as they would be on other forest land. If you're interested in regulations, we do have presentations and information that can describe those requirements in a separate presentations and separate information. If you're applying for land for the first time, you have unenrolled land that you now want to enroll or put into tree growth, there are a few steps that you need to take. The first step really is probably to have a written forest management and harvest plan prepared and make sure that you understand what your options are for management. Those plans are typically prepared by a Maine licensed forester, and there are many consulting foresters in Maine that can do that work. Your Maine Forest Service district forester can certainly aid you in finding a consultant who could help you with the forest management plan. And don't forget, I mentioned that there are a number of financial incentive programs, including with Maine Forest Service, but also with USDA, that can provide financial assistance for having a plan written. Sometimes people will believe that they need to provide that plan directly to the town. That is not the case. You do not need to provide that automatically to the town. They can request it later, but it's not a requirement of enrollment. You then submit your tree growth application to the town, And along with that tree growth application, you submit a map of the parcel that shows the enrolled and unenrolled acres. The map of that you submit often is the map that's produced as part of the forest management and harvest plan. So that usually is something that you'll have as a result of having that plan done. One of the reasons that we're talking about this sequence here is because you can't apply without signing a statement that says you have a plan in place. So you really do need to understand the program, understand that you do want to enroll, but then have the management plan done before you actually can enroll. A couple more comments about the map itself. It's one of the required elements of a written forest management and harvest plan. It has to show where water bodies are, and it has to show what the different land uses are. It does need to show where the different forest stand types are. At a minimum, softwood, hardwood, and mixed wood. Some foresters will use a more differentiated typing system, but those, at least softwood, hardwood, and mixed wood, need to be shown on your map. When you identify which acres are enrolled and which acres are not, those are then established by the map that you've submitted, and you can't later submit a different map that says, well, the way that I've enrolled my land or the areas that I've enrolled are actually in a different part of the property. The map that you submit pretty much determines where the different land uses are. Certainly, if you update or revise a map to be somewhat more accurate, that is okay. Just make sure that it's not revising it in a way that changes the actual enrolled acres. And the map itself must be updated when you do have changes in land use or changes in the enrollment. So we'll talk about that a little bit further, but really that's just sort of a key part of a forest management plan. The map is an image of the property, and as such, it really is kind of worth 1,000 words. So having a good map as part of your forest management plan is a key feature. Okay, so here's just a quick example of a very simple tree growth map. Certainly, this is an example from some years ago. Many foresters have both more sophisticated and possibly more artistic ways of depicting your property, but this just gives you an idea of one example of a very basic tree growth map. A couple more comments about the forest management and harvest plan. Forest management and harvest plan is just the term that tree growth statute uses. So you may hear of these referred to as a forestry plan, a forest management plan, or a stewardship plan, or a tree growth plan. In our parlance, we fund woodland resource action plans. They all kind of refer to the same thing, but they may have different requirements or different standards to be met. The tree growth standard is fairly basic, but it does require that it be a written document. It must be prepared or reviewed and signed by a Maine licensed forester. Essentially, that means that most plans are, in fact, written by a licensed forester. Most of them will not simply review a plan that a landowner has produced. It must contain all the required items in Tax Bulletin 19. So I'll make reference to that a few times, but that's a good source for understanding really what is required. The plan itself is not a public document. So by virtue of having a plan done, you don't automatically make that information public. In fact, towns are required to keep that information confidential. So a couple quick reminders, and I harp on these things with apologies, but necessarily because people tend to forget that the primary intent really has to be to grow and harvest commercial forest products. That tree growth is semi-permanent, really land that's classified or enrolled in tree growth stays under the tree growth tax program until it is actively withdrawn or transferred to another current use program. We'll talk about that in a minute. So the tree growth status runs with the land regardless of whether there is a transfer of ownership, whether that's by inheritance or sale or gift or anything like that. And of course, as I mentioned, the withdrawal penalties can be substantial. So once your land is enrolled, it's fairly straightforward. You want to make sure that you understand what is in your forest management plan and follow the recommendations of the forester there. If circumstances change significantly in terms of how you want to manage that property, it is okay to amend or modify things as long as you are still pursuing the intent of growing and harvesting trees for commercial forest products. I do recommend very strongly that any changes or modifications be documented by both you as the landowner and the licensed forester. So that having it written down is really important. And as I said, you must recertify at least every 10 years. And at that time, you need to update your plan and file a new application to the town. At that time, when you have that 10-year recertification deadline come up, your forester should take a look at the parcel, have a site visit. Hopefully this is not the first time that they've been back to your property in 10 years. Hopefully you've got an ongoing working relationship with your forester. They know what has gone on. Ideally, they've assisted you with some of the activities on your land. So they're in a position to inspect that property and certify that looking back, you've actually done the activities that were recommended in the plan. And looking forward, there is a new set of recommendations for the next 10 years. Having done that, the licensed forester can then sign that new or recertification application. It's the same form as for a new certification. And then the landowner signs that. Basically what you're signing is an attestation that says, yes, I'm following my plan. I have followed my plan, and I intend to continue to follow the updated plan, and submit that again to the assessor, and you should be good to go, at least as far as your obligations to the town for 10 years. Now, there are options that it is possible to get out of tree growth. And one of them is that you can transfer your land from tree growth tax program to open space or to the farmland tax program, as long as you are eligible, the land is eligible for those programs, and there is no penalty, again, as long as the land that you're switching qualifies for either the open space or the farmland program. And I'll ask Alex to jump in later on to talk a little bit more and clarify a couple of things about that. So you do have the option to transfer at no penalty to either of those programs. The second option is to withdraw voluntarily. And this does happen. People either change their mind or they find that they have a portion of the property that they want to devote to another use. Perhaps you find that you need to develop a portion of the property or otherwise change the use. And in that circumstance, you can withdraw voluntarily, submit a form indicating that to the town, and pay the assessor will determine the penalty, and you'll pay the penalty, and then you're good moving forward with the adjusted enrollment. If you leave some lands in, that's fine, as long as you still have 10 acres, or you can remove all of the land if that's becomes necessary. The less preferred option is if the property fails or the landowner fails to make sure that the property meets requirements, then the assessor can withdraw the land involuntarily to the landowner. That may occur if the parcel is divided such that there are less than 10 eligible acres. It might occur if there's a failure to follow the plan. It may occur simply because people fail to recertify. And in that instance, the town does have the obligation to give you a couple of opportunities along with a sort of interim penalty, but opportunities to come into compliance. But if you do not, ultimately, the entire property will be withdrawn and the penalty gets assessed. For land that's enrolled and then gets sold to a new landowner, again, the land stays classified as a tree growth parcel, and the new landowner essentially has 1 year to determine whether they want to continue to enroll or withdraw the property. And in that instance, withdraw the property means withdrawing with a penalty. There is no option to withdraw without paying a penalty or paying the penalty for tree growth withdrawal. If the sale of property is accompanied by a subdivision such that the parcels that remain are less than 10 acres and therefore ineligible, then that property will be automatically withdrawn by the assessor. And again, the penalty accrues to that landowner. So the new landowner, if you do acquire by whatever means property in tree growth, you have a year to file your application with the town. Make sure that you have a plan in place. The plan could be one that's provided by the previous owner, assuming that they're willing to provide it, and assuming that you are willing to adopt their plan as opposed to having your own plan developed. Certainly, it is an option to have a new plan developed as you acquire a property and do that within 1 year of the transfer. You could also alternatively roll the land into farmland or open space if the acres qualify, or you can withdraw some or all of the land. It's basically up to the landowner, who's acquired land in tree growth, to determine what course they want to take. So I've described some of the essential components. The best advice that I can give you is to go to the source for information. Tree growth is not that complicated, but at the same time, it's a program about which there are a lot of misconceptions, a lot of rumors or urban myths or rural myths or whatever you want to call them. Don't automatically trust something that you hear. Look for the best information from either the Maine Revenue Service or your town tax assessor, or from Maine Forest Service or another licensed forester. We have Maine Forest Service has a webpage devoted to tree growth exclusively, and there are a number of past presentations, handouts, documents, etc. So there's a lot of information available from Maine Forest Service's website. The Maine Revenue Services, as I said, also has a property tax division. Their contact information is there, but they're also easy to find on the web. And make sure that you're asking for the property tax division and either the municipal service section or the unorganized territory section. When you want to follow up with Maine Forest Service, you can certainly call the Augusta office, the landowner outreach forester. Currently, that's Alyssa, working in that capacity. You could also call direct just to the Augusta office and say, can you help me find who my district forester is? And the website also indicates by town by town, who your district forester is. And it's not hard to find. We are always happy to hear from people, to field questions about tree growth, to get information out. If you are interested, we are happy to schedule a visit to woodland properties and try to assist with tree growth or any other questions that you might have about your woodlands. So I'm going to stop there and turn it back over to Alyssa, who I think is going to go through some of the frequently asked questions, or the questions that were submitted ahead of time So thanks everyone for listening. I'm happy to try to help further if there are questions.
Thanks, Morton. I'm going to go ahead and I have some questions here for you, me, and Alex. The first one's for you, Morton. And if you don't hear your question as we've went through these, feel free to put one in the chat. I see we have a couple already. If we don't get to your question, please reach out to me. We can correspond through email and get you answers that you need. And I'm willing to stay on a little bit later today if our other presenters can too, but let's see if we can get this done before 1. So first question is for Morton. What should I do if my new property is in tree growth tax law and the previous landowner does not give me a plan with the sale of the land?
Right, so we do hear this question fairly frequently, and really there is no obligation on the part of any landowner who's had land in tree growth. If they're selling their property, there's no requirement in tree growth law that says that they have to provide you with the plan that they've been working under. In my mind, that's sometimes it's a great option to have a previous landowner's plan, but oftentimes, especially if the plan is older or the forester has, is no longer, who wrote it is no longer working, we do recommend and encourage people to get a new management plan written, even if there might be an older plan that's still available.
Great, thank you. And then this next one's for you, Alex. How do I move land from tree growth tax law to farmland or open space? And then a follow-up to that is, do you switch programs first or cut first if you're going to put it into farmland?
Sure. Maybe it's helpful if I give a quick overview of the farmland program, recognizing that this is not Lunch with a Farmer. So don't know how relevant it is to everybody, but if transferring any part of your property into farmland is of interest to you, the basic eligibility requirements are 2 things. One is that there's at least 5 contiguous acres of open space. And in this context, open space does mean non-wooded space. In other areas or other definitions, open space can include forested portions of a property, but for farmland, we need to see at least 5 acres of croppable land, and that you sell $2,000 or more of agricultural products. That is a pretty permissive definition of agricultural products: fiber, forage, flowers, food, feed, all of those sorts of things. So if you meet those basic criteria or think you might, and you want to transfer out of tree growth and into farmland or open space, my blanket recommendation is to talk to your assessor first before you do anything. As Morton said, the assessor is the arbiter of eligibility and enrollment, and believe it or not, with a number of assessors that are in Maine, different people have different ways they like to do things, and as long as they're within the legal parameters of the program, that's totally fine. So I would, more than anything I'm about to say, I would start with the assessor and follow their lead. If your property already meets the farmland requirements and you're already producing $2,000 of ag products on your land, it should really be no problem at all. There should be an application form, and you would relatively seamlessly transfer from one program to the other. But if you do need to cut or clear land to meet those requirements, there will at least be a portion of time where you potentially wouldn't be eligible for either program. If you clear a space and that's in violation of your forest management plan, and you're not producing ag products right away, then that could give you a little bit of a sticky situation until you start to produce food. The farmland program has a provisional classification program, so if you're not currently hitting that $2,000 threshold, but you think you will in the future, you can apply for that classification. The assessor should be able to grant it, and then you just need to come back once you hit that threshold and prove that you were able to meet that $2,000 minimum. If you aren't able to meet that minimum, then that provisional classification could be withdrawn and you might be subject to a tax penalty. Similar to the open space program, it should be relatively easy to do if your property already meets those criteria. The open space program has a little bit more of a subjective eligibility criteria where you need to convince your town office that this land is managed for the public benefit. And I really encourage you to check out the bulletin that the Revenue Service published. I think it's bulletin number 21. Yeah, 21. And we can probably link to that if that's helpful. If you can convince your assessor that your land qualifies, then it should be relatively easy. If not, and you need to make changes that would be in contradiction to your forest management plan, yeah, I just follow your assessor's guidance. That's my sort of blanket statement. I'll preface that by saying, I wonder if Mort has a different answer to that question. That's the advice that I give.
I would absolutely concur. Your assessor is a key figure. You definitely want to talk with them. It helps sometimes to have done your research, so you know what questions to ask and you know how to respond. Occasionally, assessors aren't as focused on these current use programs as they might be and might have to look things up themselves. So it helps to be prepared when you go in to have that conversation.
Mm-hmm. There's one question that just came in the chat that seems especially relevant, so maybe I can hit that before we go on. Each program has a different benefit in terms of valuation and assessment. So I think Morton said that the tree growth program is based on data published per acre valuations from the Revenue Service. Farmland is a little bit different. The Bureau of Agriculture publishes a suggested value per acre for farmland, a range for cropland, for pastoral land, for blueberry land, and the assessor should pick a value within that range unless they can justify a value outside of that range. And I will say that we're about 5 years behind on publishing that guidance. So if you want to transfer now, it's on old data and that might be to your benefit. But I hope to be able to update that with some actual relevant numbers in the coming future.
Great. Thank you, Alex and Morton. Sure. So the next one here, I'll go ahead and answer. And this is one that I've gotten a few times in the last few weeks. And is it, can you include forest roads or roads in your tree growth acreage? And much like what Alex was talking about, it is up to the town assessor, but be prepared to hear that you're not allowed to include them if the primary purpose of that road is not access to your woodland. If you're using it for forest management, they may be okay with it. They still may not, but if you're using it for recreation or if it's your driveway, those are normally excluded. The next question here for Morton. This individual has 3 acres that are not in tree growth. So they have, we'll say, a 50-acre property, 3 acres are not in tree growth. Can they move those 3 acres around on their property? The acres
the short answer is no. It's quite simple. Once land is enrolled, even if you withdraw or withhold some land from enrollment from the outset, you have to determine right at the beginning where that land is. So you can't move acres around. It's not uncommon for people to say, well, you know, in a few years, I want to build a house or I want to reserve a house lot for my kids or something like that. But you pretty much have to make the decision, where is that going to be right at the outset, and you can't move those acres around.
And as far as preparing where you're going to build structures, it's great to get the town CEO out there and figure out where you're able to actually put septic, because I've run into this issue most with landowners where the site that they wanted to build their home, they're not able to put a septic system. So getting those things ironed out before you enroll the property into tree growth. I'll take this next one. What happens if I sell a property in tree growth tax law? So as Morton mentioned in the presentation, the program moves with the land. So not the landowner, but with the actual property. So when the property is sold, the new landowner is responsible for updating the plan with their current name and their goals and turning that into the town. Okay, next one here. Can I include wetlands and shoreland areas in tree growth tax law? Morton, are you able to answer that?
So land that is enrolled and eligible for tree growth has to be capable of growing commercial forest products. So in some instances, a forested wetland that is capable of growing volumes of wood might be eligible, but other acres that are not capable of growing trees of commercial size really are not eligible. The only saving grace there is that those lands typically aren't buildable either. So in some instances that will not affect your property assessed value too much.
Great, thank you. I'll take these next two and then I have some for you, Alex. Will the town have a say in my management objectives? And will the town tell me when I must cut wood? So your primary goal if you're enrolling in tree growth tax law, as Morton mentioned during the presentation, has to be commercial timber products. But you can have other goals. In fact, I've reviewed quite a few woodland resource action plans, which if you're interested in having a tree growth plan or a woodland resource action plan that you can use for a tree growth plan, get a hold of me and we can talk more about that. But wildlife, recreation, even aesthetics can be management goals. It just, number one has to be commercial harvesting. And then the town won't tell you when to cut your wood, but your plan will tell you when a harvest should occur. So the big thing is being comfortable with that schedule and the layout of when the harvest is going to take place that's in your plan. And that's something that you should have an open communication with your forester about. Okay, these two are for you, Alex, these combined questions. Will the town be upset with me over the loss of revenue from tree growth tax law? And does the town get reimbursed by the state for those lost revenue?
No, the town doesn't get reimbursed, unless that's true about tree growth. I don't think it is, but definitely not for other current use programs. And will the town be upset? I hope not. I think that would be short-sighted for them to be upset. It's true that fewer dollars are going into the municipal coffers through property tax alone, but there's a really strong body of research that shows that it is a net benefit to the town to protect these kinds of properties. In farmland in particular, we see that farms, and this is true for woodlots, use so much less for municipal services that it is still a huge asset to any municipality to have working lands or natural spaces beyond the sort of aesthetic or environmental benefits. It's just better for the overall finances of a town to see these lands protected, and cutting property owners a break on property taxes is a way to ensure that they're protected and managed well moving forward. So I hope not, and that is a role that my office, and I'm sure the Forest Service, would be happy to support with if you do run into resistance at the assessor's level. Happy to sort of make that case alongside you to explain the program and the value that it brings to communities around the state.
I would just suggest that we might double check with Maine Revenue Services under tree growth. There is or was a municipal reimbursement program. It existed in the original law. It was not intended to be permanent, but I believe that it's still in place and hasn't always been fully funded, but there is a mechanism for towns to be reimbursed for at least some of the tax revenue that they quote unquote lose as a result. Alex, I'm going to double check that because I'm not 100% certain, but I think I might want to check on that.
Makes sense. Thanks.
And since we only have a couple minutes left, I'm going to jump to the chat here really quick. So Mike had a question about his woodlot. A lot of it sounds like it's steeply sloped. He said it's really important to the local watershed. And is there a framework for balancing harvest obligations from tree growth tax law with conservation obligations? and environmental regulations. I think the big takeaway from all of this is that if the land is not able to be commercially harvested, so if it's an area that you're not comfortable having typical harvesting equipment done on your property, that those are areas you may consider switching to open space. That is a program that's available if it meets those requirements. Because you as a landowner, you're able to set those objectives for your property. So if you aren't wanting to do commercial harvest, you may not be a good fit for the tree growth tax law program on that portion of your property. That's not to say you can't still leave the rest of your property in that. I hope that answers your question. And Alex discussed there the conversion between the different programs. This might be one that you could answer, Alex. I'm not sure here. Since there's not a penalty from moving from open space to tree growth and vice versa, is there any exemption for withdrawing properties and putting them into a tax exemption program?
Yeah, that's a really good question that I don't know the answer to, and I would be happy to learn a little bit more and then share what I've learned. So I'm alexander.redfield@maine.gov if you want to send me a note. If you're interested in the answer to that, then when I get clarification, I'm happy to dig it up, unless Morton knows the answer and I'm just wasting my time.
Yeah, I think it would be a good one to research.
Okay.
Yeah, great question. This question from Ron: you were originally charged $1,200 for your open space plan, reimbursed $600. Normally, you do have to pay a forester for their time. So if they're updating your plan, it a lot of times is not as much as the initial plan, but there usually is a charge for the forester for the amount of time they're taking to write you a plan update. Sometimes that involves a property assessment too. It's 10 years, so a lot can change. And especially if you've done work like through NRCS, or if you're cutting for your own firewood, any sort of forestry activities that you've done on your property can change what's going to be in that plan. Okay. Do lots taken out of tree growth, do they need to abut? And does that change the penalty?
So I think the question is, if you have land in tree growth, can you continually remove, can you remove it in stages, acre, a couple acres at a time? And the short answer is you certainly can take lots out and put them up for sale several years in a row. It's just that each time you do so, you'll be assessed a penalty by the town. When you take a lot out of tree growth, one of the key things that you need to remember is that you probably, if your intention is to develop that lot, you're probably going to need to make sure that there's access to that land. So I wouldn't, I would be mindful of that when you take out an acre or two here or there, just to make sure that you can actually get to that lot that you intend to develop. And at some point, you need to bear in mind that the assessor may look at a map, and if it becomes a checkerboard of lots that are in or out, they might begin to question your intention to grow and harvest commercial forest products on the remainder of the property. I sometimes use the phrase straight face test. You certainly want to be in a strong position to describe to the assessor that in fact you are growing and harvesting commercial forest products, that is your intention, and in fact that you're meeting that intention over the long term. You don't want to be in a position where you don't, where that isn't reasonably clear.
Great. I think we have time for one more here, and this is another good one. You guys have had some great questions. If you only remove a portion of the property, so if you only withdraw a portion of your property from tree growth, is the penalty less than if the whole property is withdrawn? So you are able to remove, an acre or 2 acres for a house lot, and it's going to be less because you're only withdrawing and paying for that acre being withdrawn from the program. And as Morton just explained, you are able to do that in stages, but you are going to pay each time. And it looks like Alex had answered a question here in the chat. That's a great one. So if you guys are looking at the chat here. And then I'll do one more, Francesca. I'm not sure on those numbers, and that's something that we can look into. If you want to shoot me an email, I might be able to get you a better answer. All right. I think we're at time right now. But like I said, if your question didn't get answered today, please don't be discouraged. Shoot us an email. I'm going to be in the office today and can answer questions. I'll go ahead and just put my email address right here in the chat so you have it. And thank you all for joining us today. Our next Lunch with a Forester topic is going to be on boundaries and boundary marking, and I plan to do that in May. So keep you posted through the WoodsWise Wire and check our event page. Also, if you're interested in being signed up for the WoodsWise Wire so you don't miss any webinars or events, send me an email. All right, thanks, Alex. Thanks, Morton.
Thank you, everyone.
Thanks a lot.